I'm Patrick Heller of the Natural Resource Governance Institute, and in this session we're going to be talking about the domestic legal and regulatory framework governing the extractive industries. In particular, we're going to focus on two different elements of the framework. First, we're going to go through some of the nuts and bolts and talk about the importance of a comprehensive legal framework that touches on all of the key elements necessary in order to manage an oil or mineral industry effectively. And then we're going to focus specifically on the importance of contracts in many domestic legal systems and talk about some of the risks that go along with putting a heavy reliance on large oil or mineral contracts and some of the strategies that countries have put in place to mitigate those risks. Beginning with the nuts and bolts, I want to talk first about the various legal instruments that make up the legal framework. Now, we use this graphic that you see here to illustrate the concept. It's the pyramid of legal instruments. And the idea of this pyramid is that you begin at the bottom with the foundation, which in most countries is the Constitution. Typically, a constitution will lay out certain core principles about the management of oil or mining, but it won't provide many of the details governing how those core principles are actually implemented. For example, many constitutions establish that the state is the owner of all natural resources under the ground, and that it's responsible for managing those resources in the interests of the population. Constitutions also typically lay out the basic structure of government and establish certain core economic rights that have a major impact on how the state has to go about managing its extractive industries. Some constitutions also include rights to information or other civil rights that have an impact on how these industries are to be managed. There are some constitutions that provide more details. In Niger, for example, the constitution mandates that all oil or mineral contracts signed by the government have to be published and available for the population. But this is more rare. Far more common is that the Constitution stops at the level of basic principle and structure. As you move up the pyramid from the constitutional foundation, the tools further and further up typically get more and more specific. Now, legislation is where most of the details of an oil or mining framework are typically laid out. And this is done across a range of legislative instruments. Most countries will have some sort of core sectoral law, which you can usually identify either as the mining law or the petroleum law. Sometimes they have slightly different names, but they're usually pretty recognizable. But that's not the only law that matters, as governance of the sector is embedded in various laws across the legal framework. That's often necessary in order to manage these industries consistently with the country's broader strategy for economic management. The elements that need to be covered in legislation include most of the subjects that we're covering across this course: the institutional framework and the roles of different government bodies, licensing, so how different companies get access to projects, fiscal terms, including taxation, environmental standards, labor and the health and safety of workers, customs, and public accountability. By establishing these things in law, a country is saying that they should apply against all of the actors operating in that particular sector. As we move further up the pyramid, the next level is regulation. Regulation in most countries is established by the executive alone, though there are exceptions. And regulation gets more specific than the legislation. What a regulation does typically is it takes the legislation's mandates and creates the details required for their implementation. This can relate, for example, to deadlines for applications for permits, engineering standards, or specific forms that a company needs to fill out in order to get a work plan approved. But like legislation, regulations are of general applicability. They purport to apply not to specific individuals or companies. Finally, at the top of the pyramid are contracts or licenses. Now, in this ideal legal pyramid, the idea is that a contract should be in compliance with all of the levels beneath it on the pyramid. It shouldn't have any details that are out of step with what you would find in the Constitution, legislation, or regulation. Contracts or licenses are the application of the generally applicable rules against a specific project. So they bind only the actors related to that project, and they provide the details associated with the application of the legal framework to this project alone. Here's a specific example of what we're talking about. It relates to the legal framework relating to the payment of mineral royalties in the country of Colombia. So if you start with the Constitution, Colombia actually has a slightly more detailed constitution than most. Its constitution lays out a basic principle: there will be a royalty paid on the extraction of mineral products. But that's all it says. It establishes that there must be a royalty, but doesn't say anything about how that royalty is to be paid or what it is. The bulk of that is featured in the legislation. The legislation lays out the royalty rate and the basic method by which the government is to calculate what a company has to pay. Next, we have a decree. Now, this is a slightly different terminology, but it essentially means something similar to regulation. And in the decree, Colombia lays out the specific formula called the reference price formula, which will determine how the mineral that's being exported is valued for purposes of calculating the royalty. So as you see, the bulk of all of the rules around the payment of this royalty are included in the Constitution a little bit, but mostly in legislation and the regulations. And when we get to the individual contract, all it lays out are certain particularities about the payment of a particular royalty for a particular project. So that's the conceptual framework in the ideal world. And many countries do implement just this kind of structure. One example is Norway, in which legislation provides a huge amount of detail. The graphic you see here is from a licensing round, whereby the government awarded the right to operate on various blocks on the Norwegian continental shelf. Each year, the Norwegian government awards oil and gas licenses according to a standard format, totally in accordance with the law and regulations. And all that varies in it is the ownership percentage among various actors participating in the project, and the very precise coordinates and other details associated with the specific oil block. Other than that, each license is identical. There are a lot of advantages to this kind of system. It helps the government maintain a coherent procedure for implementing its chosen strategy across a range of projects. It reduces the challenges associated with the negotiation of every single project, by which the negotiating skill and leverage of different parties can result in big differences in what a project looks like. And it facilitates effective enforcement of the rules, because regulatory and oversight bodies don't have to manage a large number of totally different systems for different projects. But the reality is that in many countries, the management of an oil, gas, or mining sector doesn't adhere to this firm structure of the pyramid. And a lot of countries, especially developing countries, negotiate extremely extensive contracts. Here's the example of a table of contents from one contract from Liberia. It shows just how much can be negotiated within an individual contract, including the terms governing exploration, public health and safety, rules for environmental management, and provisions for taxation and the payment of other fees. It's not uncommon for an oil or mining contract to be as long as 100 pages. And in many countries, they not only supplement what's in legislation and regulation, but they can actually contradict it and set up a special legal regime just governing each individual project. The reasons that a lot of countries do this are that investors may not have faith in the legal framework of the country, or that companies may put extreme pressure on a government to negotiate deals according to particular terms. Otherwise, the governments may feel that they risk losing the opportunity for the investment. When all of the rules for a project depend upon the negotiation of one long contract, it really increases the importance of negotiating skills and negotiating leverage. And countries that lack those things can get bad deals as a result. It can also create challenges associated with monitoring and enforcement, because the oversight body is now responsible for managing a whole large set of complex rules for a wide range of projects. There's no standardization, and this can harm enforcement. A contract-dominant system can also impede public transparency and hinder citizens' ability to understand exactly what their government has negotiated. This is especially true when contracts remain secret. And finally, an over-reliance on complex individual contracts can limit the state's ability to develop future policy as its expertise and understanding of the sector grow. This is especially true because many contracts include what are called stabilization clauses, which say that future legislation passed after the date of the signature or ratification of a contract has no effect vis-a-vis the implementation of that particular project. So what can a country do to limit the risks that go along with an excessive reliance on contracts? Well, the first step is to standardize terms as much as possible. Again, in an ideal world, this means including virtually everything in law and having a very simple licensing system rather than large and complex contracts. But where that isn't feasible, a country can rely on the use of a model contract, which provides a sort of second-best approach. A model contract provides a basic set of terms and allows only certain elements to be negotiated on a case-by-case basis. And that can limit the amount of variation from one contract to the next. Awarding licenses through competitive bidding is another way to reduce some of the risks that go along with contracting. Competitive bidding can reduce uncertainty and increase the likelihood that a country is going to get a good deal for its resources. Finally, the publication of contracts ensures that citizens will know the rules that apply in the oil or mining sector in their country. And it can increase public trust, both of government and of the companies that are operating in the sector. This can deliver significant long-term benefits to citizens and their governments.